We have three wonderful speakers with us this afternoon as we turn from the issue of legislative oversight to the issue of judicial oversight of intelligence activities and also of national security cases more broadly. So our panel is actually really wonderful, and I think we're going to hear a variety of views and perspectives on this. First of all, to my left, I have David Medine. David has done many amazing things on data privacy, but most recently, he has been serving as the chair of the Privacy and Civil Liberties Oversight Board, which, as many of you know, serves a critical function in protecting privacy and civil liberties as we see more and more expansive counterterrorism programs in the post-9/11 world. In particular, the P Club has issued two reports, one on Section 215 of the Patriot Act and another one on Section 702 of the FISA Amendments Act, and is currently working on the Big Kahuna, the counterterrorism programs under Executive Order 12333. To his left is Hina Shamsi, who directs the National Security Project at the ACLU and has litigated many national security cases, as well as having been involved in a variety of projects to reform intelligence laws. And finally, on the far left is Judge Robertson, who served on the District of Columbia District Court and also served for 3 years on the FISA Court. 3 years, right? Yeah. And maybe you'll tell us a little bit about your service there and why you left as well. So, and I'm hoping with these three panelists to get three very different perspectives on how judicial oversight works. David has actually graciously agreed to step in for Judge Wald, who is unable to join us because of a family emergency. So with that, I'm going to start, and I'm going to start with you, Judge Robertson. I'm going to start with a very general question, which is, can you tell us, from your perspective, what are the strengths and weaknesses of judicial oversight of national security cases, and especially those involving intelligence operations?
The first thing I have to do is to quarrel with the word oversight, or to talk about oversight versus judicial decision-making. Judges are not used to being overseers. And the oversight idea is a little strange. And the whole FISA court concept at first wasn't really oversight of everything. It was issuing warrants. Judges can issue warrants. They know how to do that. And the search warrant process that consumed the first 15 or 20 years of the FISA activities was the bread and butter of what FISA was doing. It's only in later years, we'll get to that point. Mm-hmm. But if and to the extent we're talking about judicial oversight, I have to say, and I hope this doesn't sound cynical, but I have to say that the chief strength of it is whatever public reassurance there is in finding that these unimpeachable, almost unimpeachable, black-robed, life-tenured Article III judges are deciding things. That should reassure people that there's no politics involved. I mean, even that is undercut by the whole, by some of the suggestions that the FISA court has been a rubber stamp, that it's political. I deny both of those charges, and we can spell that out if you need to. But it's the fact that judges are doing it that is its biggest strength. On weaknesses, well, we're going to get to that, I think. But in my view, the biggest problem is where I began. The biggest problem is when FISA does oversight instead of deciding between competing views of a case or with an adversary in the case. It's not doing what judges are supposed to do. It's not deciding a case. It's doing something different. It's doing some policy oversight. And I don't think the judiciary should be doing that.
So let me ask you a question about this issue about the FISA court being a rubber stamp. And a lot of that argument comes from the number of applications from the government that the FISA court has approved. And FISA court judges and others have pointed out that actually that's not a very accurate understanding of the role that the court plays, because a number of applications are modified and there's a back and forth process between the government and the FISA judges to sort of get things right, and that's why you see such a high rate of approval. But my question really is that back and forth process, which is taking place entirely in secret and behind closed doors, does that give you any pause in terms of thinking about the kind of role that the FISA court plays?
Well, I always distinguish the warrant issuance function from the program approval function, which is where I part ways with what's been happening. But as with the warrant issuance function, I wouldn't call it ministerial, but it is not, frankly, rocket science. The Justice Department people who help prepare the warrant applications, the FBI agents who do it, the CIA people who do it, all the people who are working on preparing warrant applications are fastidious, careful, precise, and if they're not, they get sent back to do it right. So it is true there's some back and forth, but it isn't back and forth on real arguments about the law. It's, did you identify this person properly? Do we know what reliance you have on this particular informant and why? Have you properly described probable cause? But that's all warrant application stuff, and I would not put an adversary in the room for the issuance of warrants any more than I would issuance of search warrants by magistrate judges.
So, Hina, you've litigated a number of these kinds of cases, and do you agree with that assessment that the strength of judicial, I'm going to call it oversight, but for judicial review, shall we say, for precision, of intelligence operations and national security cases, is the strength of the federal judiciary, and what do you identify as the weaknesses?
It's always good to start out with agreement, right? Especially with a former judge. And yes, I agree that that judicial review is a strength. Obviously, it's part of our system of checks and balances, and I think that that has been demonstrated in this particular surveillance context by the Second Circuit's decision in ACLU versus Clapper recently, in which, for the first time, an appeals court took on and examined, after an adversarial process, surveillance authorities that have been deeply controversial, that have been criticized as unlawful and overbroad, conducted a really meticulous and comprehensive analysis before finding that, in fact, the call records program was unlawful. And that is, I think, undoubtedly a strength. It's a strength of our system. It's a strength of checks and balances. The problem is that with respect to national security policies and intelligence agencies generally, this kind of decision is the exception and certainly not the rule. And I think that's a problem. In a period of time, I've been fascinated all day long and last night listening to the experiences of members of the Church Committee talking about the oversight that they conducted and the changes that resulted, at the extent to which we're now back in a period where the intelligence agencies have undergone a radical transformation in terms both of what they do, how they do it, the sources of authority that they claim, and the extent to which those sources of authority have been secret and in many instances remain secret. So you have the CIA, for example, just stepping away for a moment from the NSA, the CIA, for example, which has gone far beyond its legitimate foreign intelligence gathering purpose and engaged into the Bush administration a program of torture and unlawful detention. You have it in an expanded program under the Obama administration, where it has turned essentially into a paramilitary organization running a lethal force program far from, including lethal force, far from any battlefield. And that's just one example of a set of many controversial policies and practices which the courts have not engaged on the merits. Over and over again, in the last 10 years, we and others have filed multiple cases, multiple briefs challenging these controversial policies. Almost without exception, those cases have been dismissed. They've been thrown out on standing, state secrets, immunity doctrines, political question doctrines. And what that has meant, many things, but among the things that that has meant is that the judiciary has not engaged on the merits with some of the most controversial policies in the national security intelligence arena, with huge impacts on individuals, including the right to life, privacy, First, Fourth, and Fifth Amendment rights. And through the decision not to engage on the merits, far too often the judiciary has written itself out of saying not just what the law is, but whether the executive branch has complied with it in hugely significant areas of national security and civil liberties.
So David, you look at these intelligence programs from a different perspective. You're meeting with the NSA, you know, many days and sort of learning from the inside how these programs operate and really getting the intelligence community's understanding, as well as, of course, hearing from the civil liberties groups who are advocating on you know, reforming these programs. How do you see the judiciary as a sort of counterpart to the kind of work that you're doing in the P Club?
Well, first of all, I agree with much of what has been said by my prior panelists, and also Judge Wald might agree with what I have to say today, but my views are my own. I think the court plays an important role. I think the independence of the court adds credibility to its review. The court has sanctions. The court also has an appellate process where it can correct decisions on the way up.
And you mean the FISA court, or you mean generally?
Well, the FISA court, although we could talk later about how the FISA court could improve that, but courts generally. I think the downside of courts generally is they're not often well equipped to handle classified cases. Aside from standing issues, the process of handling classified materials, getting staff with clearances, is a challenge to the courts. And I think the courts have also shown some timidity in taking on the government when the government asserts a national security interest. They tend to defer to the government on that rather than challenge the government or look to the government to look for the least intrusive methods of collection consistent with privacy and civil liberties. So I think in some ways the courts could strengthen their review. But to make a pitch for the Privacy and Civil Liberties Oversight Board, I think we complement the court's efforts because we have some advantages. One is we have less formality. So as you mentioned, we can meet with the NSA and the CIA and the FBI informally. We can also confer with Congress informally without rules of evidence and standing requirements. And we can have a review that's not limited to legal review, although obviously we did a legal review, and I was pleased the Second Circuit adopted much of our legal analysis. But we also can do a policy review and make recommendations to both the President and to Congress, not only on whether something is constitutional or legal, which are obviously important, but also whether the program strikes the right balance between privacy and civil liberties on the one hand and national security.
So what do you think, Judge Robertson? Is that right? Do you think courts aren't well equipped to handle these kinds of classified evidence, secret, you know, creepy programs, or
Look, I could not agree more. I mean, the truth is that most federal judges defer almost automatically to the Justice Department. They bring in a guy called a security officer. They tell you what you have to do. They bring you a safe and they put it in your office, but you don't know how to open the damn thing most of the time. Your law clerks may or may not be cleared. No matter what kind of classified information you're handling, it's difficult. It's difficult to handle it. It's difficult to deal with it. But more than that, there is this deference that judges pay to the executive branch of the government in all matters that have to do with national security. And frankly, I think they should defer. Not only because it's a separation of powers question, but because what do we know about intelligence? What do we know about the merits of? We're not trained intelligence officers, although I actually did serve in the Office of Naval Intelligence for a while. I served as the administrative officer to a young captain who was running naval attachés around the country. I still don't know anything about intelligence. I mean, it's a very specialized field. And of course, security is a world of its own. we need 3 more seminars on the over-securitization of life in America, but that's not today's subject, but it does intrude on the way we handle classified material in court. So yes, we defer. And by the way, PCLOB deserves all the credit, I think, for belling the cat on the illegality of the Section 215 program. Before the PCLOB report came out and said, here's why it's unlawful as a statutory matter, everybody was chasing the constitutional issue. But the Second Circuit finally adopted the theory that PCLOB came up with, and that never surfaced in any FISA proceeding. There was no adversary in any FISA proceeding who made the points that PCLOB made. I've gotten a little off the track of your
No, that's
question,
fine. I mean, that sort of leads up. I mean, I did notice, too,
I
that
had
in
to
the
give kudos to PCLOB because they deserve it.
And certainly in the Second Circuit decision, there was a lot of reference made to the work of the PCLOB and you know, extensive citations. So that is an interesting dynamic to see between these two institutions kind of playing off each other, I think. But coming to your point about, you know, judicial deference to claims of national security, you know, there is obviously a separation of powers concern over there. But is there some instances in which we see the judiciary being perhaps too automatic in its deference to that? Maybe, Hina, you want to talk a little bit about that issue.
Well, I think it sort of begs a question about deference with respect to what. Certainly, when we're talking about the criminal context, there's the Classified Information Procedures Act, and the courts have shown themselves more than capable of being able to adjudicate cases involving national security, terrorism, sensitive information, and still do so fairly. It's one of the strengths of our criminal justice system. I think about the context of Guantanamo, where the courts in DC have, you know, certainly shown themselves fully capable of adjudicating those important habeas cases. I'll put aside for now the DC Circuit's decisions in which review has been circumscribed to, I think, the detriment of our system. But I do think, and perhaps Judge Robertson, you're being modest, but I do think that the courts are very well able to address issues of classification. Indeed, they do so all the time and every day. I think the concerns arise when, for example, the executive branch makes extreme claims with respect to classification. It did so recently in a case that is currently before the DC Circuit with respect to force-feeding videotapes at Guantanamo, where the government said that the videotapes were classified and the judge had no authority to order their disclosure, applying the First Amendment right of judicial access. There's certainly arguments to be made, but the argument made was for complete deference to the executive's classification decision. And that's something that I think we look to the courts not to do. We look to the courts not to defer when the executive branch decides what its interpretation of the law is. That is a quintessential judicial function, and the use of secrecy and classification authority, including with respect to opinions, classified opinions interpreting the law, should not deserve that same kind of deference. Certainly, I think we can all agree that there are legitimate things that must be classified and kept secret from everyone, sources and methods, for example, legitimate sources and methods. But I think we've gone far beyond that in terms of executive branch's claims of deference based on classification and other secrecy concerns, and our need as a democracy based on separation of powers and checks and balances to look at those claims of harm and so on. And I think here, Judge Sachs' decision in the ACLU versus Clapper case is really quite instructive. He points out that although the context is very different, in the Pentagon Papers case, when the judge was hearing only from the government in open session about the harm that might come from disclosure and publication of the Pentagon Papers, it looked like the government had a slam dunk case. But the New York Times had very able counsel, said Judge Sack, and in closed session, New York Times counsel questioned high-level officials at the Department of Defense and Department of State, and the judge ultimately found that the claims of harm from publication were not as strong, and the case came out the way that it did. And I think I think Judge Sack did that advisedly as a sort of recognition of the importance of an adversarial process where claims of harm and classification authority are not dispositive but are subject to judicial review.
Please.
Since we're passing praise around, I wanted to turn some praise back to Judge Robertson, who was a witness at one of our PCLAB's first public hearings and talked about the shortcomings of the FISA court process. And if I recall, said how judges hear one side of the case and find it very persuasive, as you're mentioning, and that currently is the end of the story in the FISA court. But then if the judge hears the other side of the case, they say, maybe that sounds interesting too, and that's the judge's job, is to wrestle with those. And Judge Robertson's testimony, at least for me, led to our recommendation that there be a special advocate in the FISA court so that both sides could be heard. And again, that's an example on 215, is that it took our report to essentially bring some legal issues to bear that the judges who were approving 215 every 90 days and approving the program initially never wrestled with. In fact, there wasn't even an opinion from the FISA court for many, many years after the program was already operating. And again, so that's a shortcoming, which is to say that parts of the FISA court could be improved, but it shows the shortcomings of the way it's been operating in the past. I think there's also an inherent challenge of the non-FISA federal judiciary, which is that judges are randomly assigned to cases. And this is an area that does call for a lot of expertise. So it's a challenge for a judge to push back on the government's entire national security program when the judge doesn't hear national security cases ever before or very infrequently. But I think judges wrestle with that, but that's a real challenge. I guess the last thing is the Second Circuit case, I think maybe broke some ground on standing because that, as was said before, that's been a real challenge to getting the judiciary involved in the first place, is state secrets and standing. But I think it's encouraging that the Second Circuit found standing in this case for people, the ACLU, to challenge the telephony metadata program.
Well, it looks like we're very quickly getting into the FISA court, so let's explicitly go there. So Judge Robertson, if you had been on the FISA court at the time that the Section 215 program came up to you, right? And do you think that there was a way available to you to make that process more adversarial? And what I'm referring to now is the provision in the court's rules of procedures for appointing an amicus. Was that an option? Why has the court used it so infrequently?
To be quite honest with you, I never even knew that existed and never paid any attention to the notion of amicus. And I do not believe, had I been on the court at that time, that I would have behaved any differently from any of the other FISA judges. You know, after the, in the first FISA case to go up on appeal, the one that had to do with the Chinese wall and that whole issue, Judge Silberman's opinion, infamous opinion that kind of laid it all out, made it very clear that it is not the business of FISA judges to pass on the intelligence value of anything that's being sought. That is the business of the Attorney General and the head of the Director of Central Intelligence or his or her delegates, but not the FISA court. So all they have to do is certify that there's a substantial intelligence purpose, and that issue is off the table. FISA judges are not permitted by the statute and by that ruling to look behind the curtain and find out why you're looking for this information.
But in the context of the Section 215 program, clearly at issue was this idea of what is relevant, right? I mean, the statute says you can collect records that are relevant to an investigation. And so that seems to me, you know, it's not really about intelligence value as such, but is interpreting a word that's used in many different laws, kind of across our system. So that it's sort of a classic legal issue for the judiciary, right?
Well, there I suspect that the judges on the court were the prisoners of the use of the word relevance in issues like discovery. Relevance is anything that's conceivably relevant. We'll decide later if it's admissible, but relevant is a whole big question, and relevance, there's almost no limits to what is relevant. And that's all I can say about that. If there had been an adversary, there might very well have been a different result.
So that brings us right into USA Freedom, which we talked about a little bit this morning, which is the bill that was passed through the House overwhelmingly a couple of weeks ago and is now potentially up for consideration by the Senate later this week, I guess, on the 31st, so shortly. And one of the things that's in USA Freedom is a provision that requires the FISA court to appoint a panel of people who could be called upon to serve as a public advocate at the court's discretion. What do you think, Hina? Is that enough? Does that add enough adversariality to the FISA court process to sort of bring it more into the norm of what we'd like to see?
The short answer is no. Of course, I have a little bit of a longer answer. It's predicated on the fact that I'm shaking in my shoes at what Judge Robertson said about it not occurring to judges on the FISA court who had that ability in the initial period, because in USA Freedom, certainly there's a step in the right direction in terms of, including an amicus or an advocate, but it needs to be made far, far stronger. I believe it currently stands that there are three kinds of amici that can be offered. One to provide, views on privacy and civil liberties, to provide technological views, or anything else. And this is discretionary, which is very little different from what currently exists. So at the very least, one aspect of making necessary strengthening changes would be to require, especially when there are novel issues before the court, for there to be an amicus offering privacy and civil liberties views as well as technical and technological views. Because we shouldn't be opening the door to something that's not those things coming before the court. But I think that even that is not enough. I think that there should be, in addition to those viewpoints, greater transparency with respect to the court's opinions and what those opinions are about and aimed at. And even so, and there are proposals for greater transparency that haven't yet been incorporated, but even so, I think that still isn't enough, because it still isn't an adversarial process, and I think that should be done far, far more. One of obviously the issues that are coming up is putting an end to bulk programmatic surveillance, and there's no doubt that is a very good thing, and we'll see how that debate ends up playing out. Heaven help us. But I think what we've all got to take into account is that what is happening, and however it happens, has to be the start of a new level of national conversation on these sets of issues, and not the end of the conversation on this set of issues. And so the USA Freedom still doesn't deal with all sorts of problems that exist with respect to notice in a variety of other contexts. So I'm thinking about what judicial review requires and what an adversarial review requires. And just to lay out there some fundamental problems that we still have to deal with. There are, I think, in civil courts, at least in theory, three ways in which these surveillance programs might end up being adjudicated. One is civil claims, lawsuits brought by people who have been affected or impacted by these policies. The issues there still remain standing and state secrets and need to be addressed. Another way is in criminal cases where criminal defendants might be able to challenge surveillance authorities to which they have been subjected. The problem there is that right now, notice is only being provided under Section 702, as opposed to various other provisions under which these authorities are being conducted. And even when notice is provided, the information that underlies the surveillance, the warrant, other information, is not provided. The third way, and so I think we've got to clean up those notice and other provisions. The third way in which these authorities may be challenged might be by communications providers who are, in order to provide this information. And there again, I think we have issues in that communications providers don't have the same incentives as their customers. They're immunized from any violation of law, and they don't have the same direct privacy interest. Plus, if they were to raise challenges, it would likely occur in the FISC context and still, therefore, be subject to a significant amount of secrecy. So, special advocate, amicus provisions, a real good thing. Much more needs to be done, far more needs to be strengthened to address some of these issues.
But everything you've talked about has really been within the context of the FISA court structure, right? So basically you're saying we need to improve the FISA court to make it look more like a regular federal court, at least when we're talking about instances where the court is approving sort of large programs, right? So do we then need the FISA court? I mean, if we're spending all this time and energy trying to make it look more like a federal court when it's performing a certain kind of function, right? Not the function that it was originally set up to perform, which is basically orders on surveillance on particular individuals, but these broad programs. So we're trying so hard to make the FISA court look like a regular federal court, but wouldn't it also be possible to move that function or to put it in the federal courts? Anybody?
That's a very good question. That's a very good question. I mean, I wasn't present at the creation of the FISA court. Some of the gentlemen here were. But my understanding of it was that it was fundamentally because of the sensitivity of the intelligence process and the sources and methods that were involved that led to this super secret operation that worked within skiffs and was certainly not transparent to anybody. In fact, I think probably for the first 20 years of the FISA court's existence, its existence was barely known or understood, and nobody really knew who was on the FISA court. But if all they're doing is issuing warrants, that could be done. I don't really know these days because we have plenty of secure facilities and plenty of secure communications, and all Article 3 judges are deemed to be clearable. Why that is, I don't know, but we are. So you could theoretically move that warrant process into regular chambers of regular judges. But the programmatic part of it absolutely should be done in a court that has an adversary process. Now, I take issue with my learned colleague here on whether we need whether we need to have it required by law. I mean, what is a novel issue? Do we know what a novel issue is? When would that require the convening of a court that has an adversary? I don't know. I think that the FISA judges have the requisite humility and respect for the process that they would invite panel participation. I have suggested on occasion, however, that it be required by statute that if statute or rule that if and to the extent they're dealing with these programmatic things, they must have an adversary. And if I would suggest that if any FISA judge requested it, the court would impanel 3 judges to consider what one judge considers to be a novel question, and then you'd have a kind of a 3-judge panel and the 3 judges would decide whether to invite an adversary in. So there are all kinds of ways to do it. But permanent agencies, permanent adversary agencies, no. A panel is fine, is good enough for me.
Well, PCLAB recommended a panel, but I do think the judges need more of a nudge to get them to appoint outside parties, special advocates, to represent the interest of citizens and privacy and civil liberties. There is a process in the court on Rule 11, not the civil Rule 11 for sanctions, but the FISA Rule 11, where the government indicates that there's a matter of unusual technology or raises unusual legal issues. And I think that could be an appropriate trigger for the FISA judge to call in outside party and to represent the other side. And that may be a program, or maybe it just be a new collection technique where it'd be beneficial the first time ruling on it to have an adversary to raise views. And what we called for is actually having the judges report on how often they appoint an advocate so they can be held accountable, because certainly we don't want to create the structure of an advocate and not have them use the benefit of that advocate in having true adversary proceedings. But I'd also like to mention that I think there's another category for the FISA court to play aside from programmatic approval and warrants, which is carrying out the program. Where I think the FISA court can play an important role. For instance, in the 215 program, even once the program has been approved, under the current rules, the judges, the court, have to approve each 215 request to determine if there's reasonable articulable suspicion. And I think that might be a hard judgment call for a federal judge who's not part of the FISA system to understand all the dynamics of what the investigations are of terrorist organizations and how this particular request fits in. So I think that's one example where the FISA court could play a role and not defer to the federal judiciary in general. Another is in the 702 program, where the court approves the broad program and pretty much is hands-off other than once-a-year renewal. And one of the things that PCLAB suggested, and I think will happen, is that the court be provided a sample of targets under 702 and a sample of queries that are done by the government of its 702 databases to give the court a chance to oversee the program, not just approve it initially, but to make sure the program is operating constitutionally and consistent with the statute. I do agree also that greater transparency would be extremely helpful here, and I think we might not have had the 215 process if the court had been publishing its opinions for the public to see. And what again our board has recommended going forward is the FISA judges write their opinions in a way they can anticipate them being declassified. So you have a classified section perhaps that has the facts of the case.
They're not smart enough to do that.
Well,
because somebody's always going to say, oh no, you can't. We're going to take that sentence out. We're going to.
Well, at least make that a start, and then the government can do the classification review.
Do you want to respond?
Just a small point, which is that I think part of the reason that we're having the conversation about what is the best means to fix an imperfect fix is because even though under USA Freedom, certain forms of bulk surveillance will be prohibited, other kinds of bulky information gathering surveillance will still go on. So we still have the need for special advocate in strengthened form, because we are not at the point where the court is only fulfilling the purpose for which it was initially established. And that's again why I think that we are just at the start of a conversation and certainly not at the end of it in terms of the magnitude of the reforms that are necessary.
So let me ask you a question that came up in the earlier, in the morning discussion, which is this idea of having these very complex programs and technologies. How do courts grapple with that? How do you, for David, you guys have been delving deep into some of these programs, which, must make your head hurt when you try and figure out what they're doing. And certainly some of the FISA court decisions that have come out, we've seen the court, really kind of getting deep into these very complicated issues. And so is our system sort of equipped to deal with that, and are there ways in which we can make it stronger? And I'm thinking also of the judiciary over here.
I guess starting with our board,
right.
and we have the advantage we can spend a lot of time doing a very deep dive into how these programs operate. We get briefings from the agencies, we review agency documents. We meet with congressional oversight committees, with advocates. with academics, and really can gather information from a variety of sources, which allows us to do a legal, constitutional, and policy analysis. I think that's harder for the court that has a more restrictive set of rules of evidence and what's appropriate for its communications. And of course, and the court's focus is narrower. We can look at the policy determinations. The court is looking at legal and constitutional issues.
Well, what do you, I mean, you've seen, I think, some of the FISA court opinions that have come out, and you see Judge Bates, for example, going through into, MCTs and all of these, back down to a level of detail. I mean, is there any value in having a sort of independent technological component to advise the court, for example? Because,
Well, I mean, the government advises, oh, by the way, the government does advise the court. It has been suggested, by the way, that if there were an adversary process here, that in some way the government would be less forthcoming in what it told the court. I am actually shocked by that argument. I don't accept it. I think it's sort of, judges would say, we won't hear that argument. I don't believe it, and if it were true, it would be sanctionable and worse if any government agency were caught being less than forthcoming with the FISA court because there's an adversary present. I can't really accept that argument. But as to whether there should be a special agency to advise the court, well, they have a staff. They have a staff. They are being advised by the government. And that's what an adversary is for. That's why we should have an adversary. The FISA court is not an administrative agency. It's not the P Club. And judges are not administrative agencies. They listen to what you say and decide. And for them for judges to review all the bells and whistles and say, that's okay, that's okay, that's okay, without an adversary there is not in my, I'm sorry, I'm Johnny One Note here. It's not what judges do, what judges should do.
but that's, of course, what the FISA court has been doing, right? I mean,
Yes.
when you're looking at Section 215 and you're looking at Section 702 programs, the FISA court is saying, yeah, kind of broadly speaking, this is okay, and you've got these procedures over here, and those look kind of okay. And I mean, some of what you're suggesting, David, is this kind of ongoing oversight function, which you, Judge Robertson, objected to at the very beginning, right? And so you want to have somebody kind of looking over the intelligence agency's shoulder, in a sense, and making sure they are actually complying with the rules that the court has set out. And you're saying that that's just not a judicial function. So how do we square that circle?
That's what Congress is for.
Right.
Anybody here from Congress? Fix it.
But I guess I would say that I think the judiciary, for better or worse, is approving these programs, and because they're approving them as being both legal and constitutional, I think they have a duty to oversee the programs as a compliance matter. Sometimes judges oversee consent decrees, and I think in this case they could do that. Judge Wald and I recommended in the 702 report that there's something called minimization, which was mentioned earlier, which is a bit of a failure because very little gets minimized in practice.
Minimal minimization?
Exactly. And so, but it should be, and that's really in some ways part of the constitutionality of the effort is to minimize U.S. person communications. And so one thing Judge Wald and I called for is for the FISA court to appoint a special master and have the special master review the government's minimization efforts, and if they fall short, have the court oversee an improvement of those efforts until they're finally in compliance with the procedures and with constitutional protection. So I think that's a role where the court could be actively involved in overseeing the program and making sure it's operating properly. And that's really the quid pro quo for approving it, is to make sure it continues to operate as well. And by the way, on the less forthcoming argument, I couldn't agree more. The outside counsel will be clear to the appropriate security level, and the government should trust them as much as it trusts anybody with sharing classified information. And if there's parts of the program they're not comfortable talking about, then I agree then the program should not be approved on that basis.
No, I think this entire decision is taking me back to, I think, the place that we started out and where we keep coming back to, which is the importance of an adversarial process. because remember when it was first revealed that there was this metadata program, and there were many claims by the government officials talking about how actually this is not content, metadata isn't so bad until there's more and more information that comes out from technological experts, including the expert we had in our ACLU versus Clapper case, Ed Felton, who the judges found very persuasive, talking about how much information metadata actually reveals. In fact, as much, if not more, than content, sometimes about your most personal associations and information. And I think that, when we think about government collection of information, especially mass collection of information, which technology has now permitted, we have to keep in mind what the Fourth Amendment is, which is a judgment that we do not trust the government to have that much information without real checks and safeguards, right? And one of those checks and safeguards as technology grows leaps and bounds is to have technological knowledge, to be able for judges and others to understand exactly what it is that they are approving, which is something that you can do more through an adversarial process and not as much when you have only the government's experts talking about what the privacy and civil liberties implications of certain kinds of technology are. And I think just in the ways in which over the last couple of decades or so, we've had a revolution in what the government can collect and how it goes about collecting it, and the challenges that that raises for regulation, both congressional and, I hesitate to say judicial, I mean judicial review, not judicial regulation in that way. I worry that the kinds of debates that we're having now may, in 20 more years, seem quaint. Because technology is going to continue to expand, and we need the kinds of knowledge to be able to make sure that the laws and safeguards and our constitutional rights are safeguarded in the same way, or we're going to be having these same kinds of debates after more massive violations again.
And PCLAB recommended that the FISA court take advantage of technologists. I know the government sometimes provides technological advice, but the court could go outside and get its own advice, or have the advocate provide that advice. We've been hiring technologists at PCLAB, both to help us internally, but also to help us better understand government programs where the collection technology and data analysis have become extraordinarily sophisticated, and it's important for us to have both lawyers and technologists take a look at that.
So I think this sort of brings me to my last question before we open it up for questions, which is, I was getting ready for this discussion today, and I was looking at this speech that Justice Brennan gave back in 1987, which I'd had on my desk for many months. And one of the things that Justice Brennan argues is that he says, and I think everyone can agree with this, is that the United States sort of traditionally downgrades civil rights in a time of crisis. And we've certainly seen that sort of happening cyclically across the last century or whatever. But he says that because of this cyclical nature, where we sort of, the pendulum swings one way and then it swings back and then it goes, back and forth, we haven't actually developed a very robust way of dealing with civil rights concerns during times of crisis. And one of the things that occurred to me is that, we are now in this world where we have this war on terror, the global war on terror, last I checked, which has been characterized by many people as a forever war, right? This is a war, or at least a struggle, that's going to go on for a long period of time. And so how does that actually then impact this dynamic? Like, how does that impact the sort of pendulum swinging back and forth? Because every time we think, we've sort of gotten beyond one terrorist group, there sprouts another one that we're concerned about. You've sort of dealt with Al-Qaeda, Osama bin Laden's dead, who knows how, and now you have ISIS, and probably 3-4 years from now there will be somebody else. So you'll be in this sort of constant state of lower level emergency, certainly than the world wars or something like Vietnam. But is that going to strengthen our civil liberties jurisprudence, or is it going to mean a sort of constant degrading of those protections over a long period of time. And I think it's interesting that an institution like P-Club, I think, can also play a kind of an interesting role when you're looking at a longer stretch of a lower level security problem.
Well, I think I think hopefully the judiciary sits in the middle of that pendulum and is a check on both sides. And Professor David Cole at Georgetown has written an article suggesting that in times of national crisis, the judiciary can play that role. And we certainly have seen cases in the Supreme Court on enemy combatants, on military commissions, on habeas corpus, and even going back to the Steele seizure case, where the court has played a more centrist role in trying to focus on constitutional concerns. And so, one would hope that in the political process where things may sway further, that the court would be more focused on the law and the Constitution and not be as swayed by current events.
Do you think that's really right, David? I mean, aren't you putting kind of a gloss on that over there?
I'm an eternal optimist, but the Second Circuit case is very encouraging that we're in the middle of fighting terrorists, but the court said this is a program that's illegal, and the 215 program should be stopped. Again, I hope our board also can play a role. We're independent. We don't have to clear our views with the White House or the Office of Management and Budget. We're bipartisan. We have 3 Democrats, 2 Republicans. And so I hope we can also try to be very fact-based and do clear, strict legal analysis and be transparent about our thinking as well.
But let me push you on that a little bit too, because I mean the P-Club has split, right? I mean, it is bipartisan, but on some critical issues, you haven't actually managed to get consensus amongst your 5-person board. And so, I mean, how does that then, I mean, doesn't that just kind of reflect the same kind of tensions that we see?
I think there are challenges, but we've certainly been transparent about our board's views. And as I look around town, I don't see the Supreme Court being unanimous every time. And last time I looked, Congress wasn't unanimous every time. And so I don't think it's surprising that when you invite 5 people to come in and bring their different perspectives, they may see things differently. So I think being unanimous sometimes means the least common denominator. And I think it's maybe more important to show our differing views and our analysis to inform the public debate. And again, it's encouraging that we recommended the end of the bulk collection program. A majority did. The president adopted it right away. The Second Circuit adopted it, and perhaps on Sunday the Congress may adopt it.
Perhaps. Judge Robertson, what do you think? I mean, as a judge, having sort of seen these national security pendulum swings, right? I mean, does the fact that we have this like long-running thing, is that going to make a difference?
Yeah, I think it's going to make a big difference. I think the suggestion is that the judges, the judiciary doesn't swing as far as the pendulum swings. It's probably right, because we're all Americans and we all swing with the pendulum a little bit, whether we think we're doing it or not. Justice Brennan was absolutely right that judges tend to sort of think about, fly the flag in their head and get all patriotic, and there's danger out there and we have to be aware of danger and so forth. But the longer this war on terror goes on, the more sort of immune we're all getting to these alarms that are being sent out all the time. And I really think that we're getting into kind of a steady state situation where everybody's worried about national security all the time, but it's not driving us nuts. And I think the judiciary is going to continue to do what the Second Circuit did, and is going to find the bottom of the pendulum swing and begin to deal with these national security cases without being stampeded by terrorist concerns.
Are you as optimistic?
I'd like to be. And in some ways I am. I think that there are causes for optimism. One of the things that Justice Brennan said in that speech was part of the cyclical nature is that once you come out of the emergency, the country remorsefully, regretfully realizes that the abrogation of civil liberties was unnecessary. And perhaps we are getting somewhere to that point. I think about recent polling that we did in which a majority of Americans thought that more constraints needed to be placed on surveillance authority. Think about the fact that it may very well be that Section 215 sunsets as a result of where we are. That kind of thing was something advocates have long sought, but seemed unfortunately far off. Where I'm a little bit less optimistic and more concerned is the claim of war-based authority, right? During previous wars, we largely understood when wars would come to an end. We had more defined enemies. And here, at this point, we have very little notion, based on how the executive and Congress going along with the executive in many ways have defined who the enemy is and how wars might actually come to an end. And there are claims of war-based authority to use lethal force and to unlawfully to detain far from any traditional battlefield. And those authorities have not yet been subjected to the kind of scrutiny that I think courts may be more and more open to. I'm reminded here of Justice O'Connor's plurality in Hamdi, where she talked about how the understanding that informed the court's decision to say that the detention of an enemy combatant was lawful, albeit subject to review, that detention authority might come to an end if traditional notions of war unraveled. And I think we may be getting to a point where courts are willing to look to those traditional notions a lot more searchingly, perhaps even skeptically. I'm thinking of decisions that have started percolating in the domestic context with respect to domestic authorities, surveillance obviously being one with respect to Americans, but also with watch listing, for example, which has been one of the significant increases post 9/11. And last year, a federal judge ruled for the first time that the government's redress process for providing redress to people who sought to challenge their blacklisting status on the no-fly list was unconstitutional, and that the government's GLOMAR policy of refusing to confirm or deny that people actually were on the list could not stand, despite the government's claims of extreme national security harm occurring if that were to be, if that were to happen, which it hasn't. And so I think that there is some real hope and some room for hope. I certainly hope so. I feel like I'm in the business of hope. But I think that there is a lot of room for great caution because a lot of the claims of authority and extreme authority continue.
Okay, well, I'm sure there are folks in the audience who have some questions. The hands are going up, please.
Hi.
Oh, could you please introduce yourself when you ask your question?
Hi, Tim Sparapani, concerned citizen.
We like that.
I have two related questions and an observation, and I'll try to be very brief. It seems to me that none of the oversight mechanisms or review mechanisms that we've talked about during this panel deal with the problem that Mike German was talking about earlier in the day with respect to the outsourcing of any of the intelligence function to third parties, and in particular data brokers. I'm wondering if the panel could talk about where, if at all, one would go to get oversight or review of the outsourcing or privatization of that function within the national security apparatus. And then a related question, which is, if you look at the statute that underlies the authority for the P Club, it's actually quite limited as to the remit of the P Club. And so my question along with those lines is, in relation, should the remit of the P Club be broadened, or do we need perhaps multiple P Clubs given the breadth of programs that are out there that may in fact need some second eyes on them? Thank you.
P Club's jurisdiction is limited to federal counterterrorism programs. We certainly have had plenty to keep us busy in our 2 years of existence so far. There is legislation pending that would expand the board's jurisdiction to foreign intelligence and not to counterterrorism. We have taken a position on that, but at least there are people in Congress who seem to be thinking along the same lines. And I guess my view on the outsourcing question, at least from P Club's point of view, is that if it's a federal counterterrorism program, maybe carried out through contractors, I don't see why it would not fall within our oversight jurisdiction.
I have no view on the outsourcing question, but as to where the writ of P Club runs, I suggested at that first meeting that the chairman was talking about that actually P Club should be the adversary in the FISA court, and P Club said, "Oh no, not us."
I should say in part because we do have another function besides oversight, which is advice, where we give agencies advice as they develop new programs, new laws and regulations, and we hope that this will help them get it right at the beginning and not have to be criticized later on. But it would put P-Club in a challenging situation to have advised about the creation of a program and then challenge that same program in court. And that was, I think, at least part of the motivation why we prefer to have outside lawyers serve as adversaries. Although I guess the USA Freedom Act has the court consulting with P-Club in determining which outside counsel to choose and to put on the list.
Do you want to talk a bit about outsourcing?
Just that I think it is a pressing issue and absolutely needs to be dealt with in multiple ways. The ways that it has come up most prominently, I think, as you probably know, Tim, has been in the context of outsourcing to military contractors in war zones where abuses have occurred and lawsuits have been brought. And there's been some, but certainly not enough accountability in those contexts. But I think that with respect to intelligence outsourcing in the same way, absolutely far, far more needs to be done.
Liza?
Hi, Liza Goitin from the Brennan Center. You talked about the barriers that standing and the state secrets privilege pose to review in regular federal courts of a lot of these surveillance programs and intelligence programs. First of all, I'm just wondering whether all of you agree that that is in fact a problem that needs to be solved and not just sort of an unfortunate feature of our courts that they can't decide these cases. And if that's true, where does the solution lie? Is it in the judiciary, that the judiciary needs to rethink its position on these questions, or is it legislative? Should Congress be legislating on state secrets and on standing? What is the solution there?
Bert already has his hands up. Chui.
Yeah, please. And then Bert can maybe weigh in as well.
So I think with respect, let me just start with standing. I think that, you know, in regular cases where you're required to show an actual or imminent injury in fact, it isn't the case that generally you have to show the injury has absolutely occurred, right? And in the surveillance context, however, especially after Clapper, there's been far more of a stringent requirement of showing that the injury has happened and has occurred already, as opposed to, for example, what we argued in that context, which is that it was absolutely likely that it would occur in the imminent future and that reasonable efforts had been taken to mitigate that injury. For example,
you're talking about the first Clapper
the
case.
first, sorry, amnesty lawsuit that didn't persuade the Supreme Court on standing grounds, I should add, but that you know, reasonable efforts have been taken through expenditure on encryption or travel by lawyers and journalists and human rights activists and others who were going to be subjected to that surveillance. And of course, it turns out that, you know, a few months later that the Snowden disclosures showed that, in fact, that was a reasonable expectation. So one way I think to do it would be for courts not to impose a special standing rule in the surveillance context, especially given a context in which the circular logic of two administrations has been that in order to challenge, you have to know that you have been surveilled and show that you've been surveilled, but we're going to hide and not tell you whether or not you've been surveilled, so therefore you can't challenge. So I think that sort of outbreak, there's potential congressional fixes that could be made. Steve Vladeck has a very interesting article on secrecy and surveillance, talking about how Congress could legislate the kind of injury that could be shown given the kinds of programs that exist. And so I think that there are real fixes because there are real hurdles. Standing is a real hurdle. It has been, until very lately, the hurdle that has kept these cases from being heard on the merits. Similarly with state secrets. one change between the Bush and Obama administration was the internal guidelines that Attorney General Holder established that raised the threshold of when the administration, or purported to raise the threshold of when the administration would invoke state secrets. I come to think of those guidelines as the albeit reluctantly standard, because the difference, it seems to me, has been we're going to invoke state secrets, albeit reluctantly. And that state secrets have been invoked as much, if not more, including very recently in a very new context. And I'll just throw this out very quickly, the Restis versus Ioanni case, which is a private lawsuit, private defamation lawsuit brought by a businessman against an advocacy group that sought greater sanctions against Iran. And in this absolutely private lawsuit, the government intervened as a third party to seek dismissal of the lawsuit on state secrets ground. Now, state secrets has been invoked to throw out lawsuits based on torture, warrantless wiretapping, racial discrimination, but at least in those contexts, we, the American public, had some idea of what the government's interest was at stake. In this case, we have absolutely no idea of why the government would seek to have a suit between private parties dismissed. So the albeit reluctantly standard has taken on new levels very recently. And there has been, not so strong now, but there have been movements for reform, legislative reform of the state secrets privilege. And maybe I ask Bert to address that, because it hasn't gone as far as it should, and it's necessary.
Well, why don't we get comments from our panelists, and then we're going to ask Bert to maybe talk about that. Did you want to respond to the question? Do you
about
think
standing and
state secrets? I mean, do you think that's a problem?
Well, district judges are modest people, have much to be modest about. They don't understand standing, just as Chief Judge Michel will tell you, they don't understand patent cases either. And with all due respect to you, David, I'm sorry Pat Wall isn't here, because she could explain standing to you, because she sits on the court that talks about standing. We in the district court are taking these blind guesses about what standing is. If I can digress for 10 seconds, I will tell you that now in my private sector life, I'm doing a lot of mediation and arbitration, and I realized when I started doing it that, guess what? I didn't have to jump through all the hurdles that district judges have to jump through: jurisdiction, venue, and standing, and justiciability, and ripeness, and on and on and on and on before you ever get to the merits. You parachute in the merits, you solve the problem, you go home. That's the way the courts ought to work, but they don't. And that's what standing is a very, very complex, difficult, and I'm sorry to say necessary concept. But I don't think you can legislate standing out of the woods and say, well, if anybody is upset about what the government is doing, they can come to court and challenge it. That's a recipe for disaster in the courts. We have millions of suits of people who don't like what the government is doing.
I think the question is a more precise one, right? So this actually goes back to Laird, right? The Laird case, where it was decided that the chilling effect of surveillance is not a sufficient harm for you to have standing to sue the government on a surveillance program. So in that sort of limited context, you might have a legislative fix that recognizes that as a cognizable harm for purposes of these kinds of lawsuits, which would, perhaps solve the issue that we've had at this sort of circularity on the surveillance issue.
And I think that's a problem that the 215 program exemplifies,
right,
which is that the fact that people know that their phone records are being kept by the government chills their First Amendment rights. They're less willing to associate with each other, knowing the government is monitoring them, less willing to talk to the press, to speak, to associate with religious organizations. And so I think relaxing the view of what is sufficient chill to create standing, I think it's something that could be done either legislatively or judicially, but would certainly benefit the ability of the courts to wrestle with these programs.
So Bert, I know you have something to say on these issues.
Actually had a comment and a question about earlier issues, but on state secrets, as I said this morning, the House Judiciary and the Senate passed state secret legislation, And the only thing I would add is that Attorney General Mukasey and then the Obama administration, after more of an internal debate, opposed anything but a real weak law. And General Mukasey emphasized the Supreme Court case in which he quoted them as stressing that the Supreme Court had always held courts should be extremely deferential to the executive branch on national security. And we pointed out that he left off the end of the sentence, which was, comma, except when Congress expressly provides otherwise, which was from the Justice Department brief in that case. But I wanted to go back to just 2 points.
Sure.
And raise a question. I share David's optimism about the courts. I've been involved for 50 years closely in judicial confirmations, and I think there are 2 things that bend the judiciary's arc towards skepticism. One, the older generation of judges from World War II who saluted the commander-in-chief, they have left the bench. And secondly, all the revelations from the Pentagon Papers, Watergate, Iran-Contra, and so forth have made judges much more skeptical. There was a deflection from that path as the conservatives got a lot of young, very conservative courts of appeals judges. But now, as the far right, if you will, is joining the left on civil liberties issues, I think that path towards more skepticism by judges. Also, they have become more comfortable dealing in Article III courts with very classified information. So I think that arc is bending the right way. But my question goes back to the issue about the FISC and changes in it. If you distinguish between special masters, which Pat Wald made very good use of in FOIA cases when she was on the court, and she was our best witness on state secrets, by the way. If you distinguish that, which judges on the FISC, I assume, have been able to do, from the idea of a counterweight, whatever you call them, I was wondering where you would draw the line, because this morning was pointed out the original concept was sort of a magistrate on warrants, but that is ex parte. You do not have an adversarial procedure. So I assume when there's a big program or interpreting the scope, you would hope there would be one appointed. But suppose you have a specific warrant investigation that in effect involves complex issues. Where do you draw the line in terms of when you either should mandate or strongly nudge towards an adversarial proceeding, and where it really is closer to the traditional, under the Fourth Amendment, ex parte warrant proceeding?
So I'll ask you all to answer that question, but also to sort of maybe talk a little bit, and I think, Hina, you alluded to this issue, which is, you know, in a warrant proceeding, you do, in many cases, have a criminal proceeding to challenge subsequently, and what are the differences between that sort of normal criminal model and what we see in the FISA context? And maybe, would you like to start us off?
Well, I'm not sure quite where to intersect with all those, with that thinking. If we're talking about special masters, I mean, I don't see any utility of a special master in even the complex warrant situation, because this warrant thing moves fast. It's not something that you don't issue a warrant, you don't apply for a warrant that you're going to use in 6 months. You want it yesterday, and the warrant application process takes, I think, a few days before warrants are issued, and there really isn't scope for magistrates and special masters and extensive investigations. On the programmatic side, however, absolutely there should be some sort of help given, but in my view, it should come from the adversary, not an ex parte magistrate.
I meant 2 different things. The adversary talking about constitutional issues, civil liberties issues, the master as an expert in IT or intelligence intricacies as it's a separate kind of assistance to the court. So Pat Wald appointed a special master in an FOI case who had been in the Justice intelligence area, and he was able to whittle the government's objections from 80 down to 3 or something. So that, I was talking about just expertise, not the kind of arguments that an adversary would make.
Well, maybe that'll work. Maybe it would work. I mean, I don't know if it's if it has been or is being tried. It would be sort of, if you can use this word, it would be sort of a creative thing for a judge to do, to reach out to get a special master to talk about the details of IT. But I don't reject it. I just rather have the adversary hire the expert and have the expert teach you.
As I mentioned earlier, though, Judge Wald and I made the recommendation, drawing on her FOIA experience with the special master, the review of minimization by the government, where I'm not sure a federal judge is going to sit and look at intelligence files and see if they were properly redacted, or if they had no foreign intelligence value, they were destroyed. But that would be an appropriate thing for a special master to look at a random sample to make sure that minimization procedures were working properly, and then report to the judge, and then the judge could issue relief if necessary.
Where do you draw the line on the adversary between a, quote, warrant, specific warrant, and a larger issue?
Our board's recommendation was on matters involving novel, legal, or technological issues.
That's where you would have had a special advocate, and then
special
you
advocate.
envision the special master as part of the ongoing kind
Yes.
of compliance review function, right?
Exactly.
Did you want to add something?
Yeah, just a couple of small points that your question raises, Bert, which is just under the original conception of the FISC and how it was justified. It was analogized very closely to a magistrate issuing a warrant requirement, which of course is far from what has subsequently happened. But even in that context, in the criminal context, there is the idea that should there be a challenge, it would be brought later on. And that kind of challenge is not envisaged here. And I think I would be remiss if I didn't mention a second part of this, which is the parallel construction problem, right? Which is when information obtained through these authorities is provided and disseminated, and the government then constructs a case so that notice either doesn't have to be provided, or it appears that these surveillance authorities haven't been relied on, so that the constitutional issue cannot be raised in the criminal context. And I think the final point here that's worth remembering is for how long notice actually didn't happen. So when in the Amnesty International case, the Supreme Court said, who would ever have standing to bring a challenge to these authorities, the Solicitor General said, well, a criminal defendant against whom these authorities are concretely used in court. And apparently what the Solicitor General did not know was that the National Security Division's policy was not to provide notice to criminal defendants. Now, we've had notice provided in some cases, still not perfect, in part because these cases often plea out, government isn't providing the warrant-based information, but that's still a fix that absolutely needs to happen.
So I think, Fritz, you get the last question.
Well, I have one comment and one question. The comment is going back to your original question about whether the FISA court has been a rubber stamp. If you just confine the issue to its warrant function, which was its only legitimate function as we conceived it, I don't know what back and forth there is in the proceedings in front of the court, but clearly the government isn't even seeking warrants of the kind the Church Committee exposed, Eleanor Roosevelt, the Southern Christian Leadership Conference, the American Friends Service Society, and Supreme Court justices. They're not seeking those warrants, and hopefully they're not wiretapping those people. So it's a little unfair to call it a rubber stamp just because they approve at the end of the day most things that do come before them. Now the question is, Judge Robertson, you said you thought, I think you said you thought the reason courts are reluctant, have been reluctant, Pat Wald said extraordinarily deferential to the government in FOIA cases where national security is claimed and in state secret cases, was because they felt they weren't expert. But courts handle all the time questions where they don't start out as being an expert on the subject. I've thought it's because they're afraid of being wrong in a national security context. And it does help. Lou Oberdorfer, predecessor at your law firm, used a special master in a FOIA case in which the Department of Defense was agreeing on something like 5% of the documents, and after the special master looked at them, they ended up agreeing on 80% of the documents. So the question is, what can we do to make judges feel more confident in taking on national security questions?
I think Bert wants to make a small intervention before we turn it over to our
In
panelists.
response to Fritz, in 1975, Phil Hart got an amendment to the FOIA Act which said when there's a court appeal from an agency denial, the judge is directed to make a de novo determination of the claim of national security balanced against the purpose of FOIA. Unfortunately, in the conference report language, they put in some stuff about deference, so most judges have treated it as a dead letter, but it's already statutory law.
So I'm going to give our panelists a chance to make some last remarks. You want to start, David?
Well, again, I think there are some institutional challenges in the courts in terms of classified information, deference to the government. But again, I think we have seen the Second Circuit, hopefully some more circuits soon, standing up and boldly expressing their views in favor of civil liberties and compliance with law. And so I guess I remain optimistic. I do think that it's critical to reform the FISA court outside of its warrant function so that it performs more effectively. And I think USA Freedom Act goes a long way toward doing that.
Robertson?
After you.
You're next in line.
You know, just on the Freedom of Information Act, Fritz, I think there is some greater hope than perhaps I started out with. I'm thinking of the DC Circuit and the Second Circuit both in FOIA lawsuits seeking transparency about the administration's targeted killing policy and the use of drones. You know, one circuit said that it was implausible that the CIA does not have an intelligence interest in the program, and the CIA could not invoke a, you know, neither confirm nor deny response. I think it's very encouraging that the Second Circuit ruled as it did last year, where it recognized that when administration officials essentially campaign to convince the public that a program is lawful and effective and wise and seek to justify that, they cannot then seek to withhold the bases for their decisions, and ordered the release of a memo that justified the targeted killing of a US citizen. And I think far more needs to be done. I think we need just not only the legal memos, we need the facts, and the same kinds of reasoning might apply in multiple other contexts where I think there's room for the judiciary to be more skeptical about claims of national security harm, which is essentially what these cases come down to in the FOIA context. You know, with respect to USA Freedom, I think, you know, there are opinions that are genuinely sort of angst-ridden and divided. I think that there's significant reforms that need to be made to that statute. The ACLU has not taken a position for or against it. And, you know, it's a step forward, but much more needs to be done. And our thinking is probably on balance that it should sunset, and we should be able to have a conversation that starts out from basic premises, given where we are now, knowing, as the PCLOB and the Presidential Review Group and the DOJ's Inspector General has said, that at least Section 215 authority has not been critical for stopping any kind of terrorist attack. And that perhaps is where we are able to have more of a reasoned and reasonable and less emotional debate about these kinds of issues.
I'm back with Fritz Schwartz. Question of whether it's lack of knowledge or fear that makes judges, fear that they may be wrong, that makes judges defer the way they do. And I see that actually as sort of two faces of the same problem. I may not be smart enough, I may be wrong, I may get somebody killed. All that goes into the algorithm that goes through the judge's head when the judge is making a decision. I I like the idea that the confluence of the left and the right on civil liberties is going to make judges is going to make judges more skeptical and give judges a little more room to speak out than they have felt they should. You know, the truth is, and maybe it's just a generational thing, but the truth is that when you get an Article III appointment for life, you take on a heavy responsibility to everybody. And it isn't just you out there swinging away at whatever targets you want to swing away at. There are all kinds of other forces operating on you all the time, and judges do, certainly at the district court level, they tend to be perhaps overly modest. A few have the guts to speak out, and God bless them. Judge Lynch in the Second Circuit, God bless him. That was a great opinion. And, but it's not going to be every judge all the time. It's just going to be a few.
Well, thank you very much, and I hope you'll all join me in thanking our panelists for a really great discussion.